Yes, Mr. Lewis.
Thank you, my lord. Before I recommence, I've got 3 items of what we planners always call housekeeping when
Yes.
we're doing planning inquiries. So if I may, items 1 and 2 are to produce copies of, respectively, section 38 of the Planning Compulsory Purchase Act 2004 and the Paul Newman case, which I mentioned, in which Wavendon is approved. So when the court has those, and there's one other point of fact which I have to mention, which my learned friend Mr Tucker brought to my attention. Paul Newman I'll come back to in due course, but it's section 38. I mentioned the neighbour section, section 38.6, or the neighbour subsection, section 38.5,
Yeah.
which is the one which tells everybody that a plan which is the latest approved takes precedence over any other plans. And that's development plans, that's not emerging local plans. That's primacy of development plan. Paul Newman, I said I would come back to. The third matter is my learned friend Mr Tucker drew to my attention in terms of when the allocation was first ever thought of.
Yeah.
It was first put forward in the consultation draft as a draft consultation allocation in July 2019, but the site had been identified as a potential site, albeit not at that stage as a potential allocation, in a document which is the predecessor to the consultation draft of the draft local plan, and it's called the Issues and Options document of 2017. And as I think I just said, the Bayton Road site was identified as a candidate site there, but it's only a candidate, it's not an allocation.
Yeah.
That was when it was first put into the planning process as a potential allocation or first identified. So coming back to my submissions, I was just going to round off on ground 1 by saying that on the basis of the council's misconstruction of policy 1, that was a plain misdirection. And the words plain misdirection I take from the Mansell case. I'm not going to take a lot of time with that, but simply to identify where it comes. That's paragraph 42.3 in the authorities bundle, 42.3, forgive me, tab 3 in the authorities bundle, paragraph 42, subparagraph 3.
We'll need a page number since we lack dividers.
I do apologise. That page
Starts at page
number
42.
is, yes, I'm grateful, it's 58. I'm sorry. It's 58 in the bundle, or in the report itself, it's 1468.
Yes.
And it's 42.3, and the reason I wanted to take the court to the paragraph is for 2 particular reasons. It's to indicate that where one sees the words plainly misdirected in the bottom line there, that's in the context of members being misled in the case, or the decision maker being misled. And so in my respectful submission, and going back again, if I may, to my Lord Justice Singh's point about what difference does it make if you've got section 38.6 and you've got development plan on one side and material considerations on the other. If there's a material or misleading or plain misdirection in relation to a central development plan policy, then again, as I probably did say before the short adjournment, that alters the basis on which the planning balance falls to be undertaken. It alters the balance of considerations. And even though my Lord Justice Singh raised the point, well, there's policy CS2, and that's about settlement boundaries, But if that's downplayed by saying that's all right, that's out of date, therefore tilted balance, and so that's an added point in favour of the applicant, actually, if that's wrong, because sitting behind policy CS2, there's actually a brand new policy 1 in the neighbourhood plan, which is up to date, and I'll come back to my Lord with Justice Lewison's point about, well, mightn't the neighbourhood plan be regarded as out of date now if it's out of step with the latest figures for housing? No, my Lord, it's as it were bang up to date. It's the most recently adopted plan, and it's the one which says no development outside the settlement boundary, which is my unhesitating submission about what policy 1 means. So that's why I took the court to Mansell. There is a plain misdirection here. It's not one which can be saved by reference, as my learned friend Mr Tucker referred to the Chichester case, and just saying, oh, look, there's this policy there. If it's out of step with that policy, it's a support policy. Take the court to Chichester now. That is tab 6. Page 133, I'm grateful. Chichester, and in that case, the relevant policy was the one which said, forgive me, it's the one which says support. My eye is not lighting on it.
Is it page 140?
Indeed it is, my Lord. It's policy 1 in paragraph 18. I was simply losing it. I've actually got a yellow sticker in there. I am grateful. It's policy 1, which said the neighbourhood plan will support development located. And that was held to be, perhaps not surprisingly, not a prohibition on development outside, because what it says is it supports development within. But importantly, on all of these cases, and this is what Chichester says itself in terms, dotting now ahead to page 147, paragraph 32, page 147, paragraph 32. That says, as the authority shows, the circumstances in which these basic principles are applied, that's the Hopkins, Holmes, etc. principles, will vary widely. Reading the analysis across into another, in one case across into another, can be mistaken. No two plans are the same. So that's even if Chichester were a case where the policy said, well, development shall be focused within the settlement boundary. Lord Justice Lindblom here, Senior President of the Tribunals, is counselling caution against simply reading that across, because no two plans are the same. And again, critically here, I won't repeat the points I made before the short adjournment, but given that the policy says what it says about focusing development within the settlement boundary, you test that with subparagraph D, which gives you an exception to that policy. That helps you with what the word focus means. And you've got the text in paragraphs 4.1 to 6, which says, to paraphrase very briefly, essentially, enough is enough. We've got the Thurston 5, that is it. Yeah. That's why we're drawing the boundary. That, in my respectful submission, is the end of the matter. And so any development outside that settlement boundary is in conflict with the policy. That wasn't reflected, acknowledged, accepted by the council. Therefore, they misled themselves.
Could you just show us where in the officer's report he misconstrued the policy?
Yes, because he does not ever say that the proposals are in conflict with policy 1. He does not say that.
And that, you say, must mean that he misunderstood policy 1?
Yes, Mike.
So it's not that he positively put forward a wrong interpretation. He didn't deal with the point. Is that what you're saying?
Well, it doesn't matter whether his construction was positive or not, my lord. What he didn't do, to put it in Waverland terms, he didn't put it into the basket.
But he didn't. I couldn't see that he attempted to interpret the policy anywhere in the office.
Well, then if he didn't, my lord, that is an error, because it's a policy which was plainly material, if I put it that way.
And he had a duty to interpret it, did he, rather than just bring it to members' attention and say, well, there it is?
Or they had ultimately to reach an interpretation of it, and there's no interpretation of it. There's no evidence as to the interpretation of it which they reached.
Well, does that demonstrate a legal error? They may have got the interpretation completely correct. Surely it's for you to demonstrate that they misinterpreted it.
Well, forgive me, my lord. It's not purely a burden of proof point, my lord. It's looking at what the decision was.
Yes.
And there is nowhere in the decision, they do have a bit in the decision where they talk about development plan.
Yes.
But they don't say, here is this development plan policy, and on Wavendon, which I am going to come on to, and on Wavendon, they have to decide which are the most important policies for determining a planning application. They don't stop and say, well, clearly, this policy about settlement boundary being one which does need to be relied on, because we're not relying anymore on policy CS2, it has to be a policy which they rely on, or deal with, to put it that way, grapple with.
Mr. Lewis, like my lord, I'm afraid I'm having difficulty understanding how this is a misconstruction case as opposed to arguably a misapplication case. Because I could understand if, for example, there was said in an officer's report that the phrase settlement boundary means the parish boundary, then I could see that that is a plain misconstruction of a policy, and there would be a question of law for us, for any court, to determine. But here, what you appear to be saying is not that the planning officer's report anywhere misconstrued policy 1, but that he must have misconstrued it because it's obvious that this development proposal is a breach of policy 1. But that sounds like an application of policy rather than its interpretation.
I follow the way your lordship puts that, but nonetheless, I don't hesitate from saying that it was a matter under section 38.6, because it was a development plan policy, that it did have to be, forgive another colloquialism, I was going to say put in the basket, but it had to be put in the frame of development plan policies. And that was a task, aside from whether development plan policies pull one way or the other. It was something which the officer, and thereafter the council, had to decide which way it pulled.
But
and so if they don't mention it, that's
was
not...
put into the basket. The officer's report quite clearly put it into the basket. If you're saying he misled the members about what policy 1 meant, I would like to see where he did that.
Very well, my lord. That would be the transcript.
Right, so it's not in the officer's report.
Not...
Is that right? Not in the officer's report.
Forgive me, my lord, before I answer conclusively to that, what is said in the officer's report, and there's one passage in 2018, this is not on page 2018 in tab 8, forgive me, this is not about conflict with the neighbourhood plan, but what this is saying, 384 on page 218.
I'm lost with the references. We're in with tab 8.
Which is the report,
yes.
My lord, and it's page 218 of the bundle, using the numbering in the very bottom right-hand corner.
Yes. 218, yeah.
Paragraph 384. And what the officer says there, admittedly, it's the words serious conflict of approach in the middle of this paragraph. But what the officer is saying there is that the neighbourhood plan, the statutory development plan, is seriously in conflict with the approach in the joint local plan. So I accept your lordship's point that here there's not a reference to policy 1 and saying and interpreting it one way or the other, but what the officer is saying is all the other policies in the non-statutory plans, or the ones which are out of date, serious conflict in approach between the neighbourhood plan and this direction of travel which comes in later.
And isn't he right about that?
Well, no, my lord, because the joint local plan is a draft plan. It's not a statutory development.
He says that more than once in this report. He says it in the first 2 lines of that very paragraph.
Well, very well, my lord, but with the neighbourhood plan having been a recently adopted statutory development plan, it needs to be taken into account. It comes back, or if I put it in terms of, well, I was going to say, do I need to fall back on material considerations? I don't need to fall back on material considerations of something which inevitably should have been taken into account as potentially influencing the decision, or as influencing the decision one way or the other. It's required to be applied because it's a development plan policy.
Where does he misinterpret it? I can't see any interpretation of the paragraph you've shown us. He says there it is. It conflicts with the draft joint local plan. It's a conflicting approach. Where does he say, and looking at policy number 1, I think that it doesn't present a barrier to development outside the settlement boundary? I can't see that he says that anywhere.
Without being flippant, my lord, if it doesn't say that, it should do somewhere. And reminding myself that the development plan is the starting point.
Right.
And so
he says that more than once.
Well, yes, he does, my lord, but it's not a question of the application of the policies. He doesn't address the policy. If I put it the way I put it a moment or two ago, was to say he doesn't grapple with it.
Well, he doesn't interpret it.
Well, yes, and then if he doesn't interpret it, my lord, he jolly well should have done, in my respectful sense.
Right, so it's not a misinterpretation you rely on, it's a failure to interpret.
Well, so be it, my lord. And because there's such a wealth of documentation in this case, my lord, I'm not absolutely sure it will be in the bundles which we've got, but the parish council very clearly said this is our plan and the development will be in conflict with it. And to the extent that they were correct about that.
That's what they said, and that's what the planning officer summarised in his report, isn't it? Pages 160 to...
Yes, that's correct, my lord. He summarises the representations.
Yeah.
But to the extent that he doesn't agree with the parish council saying that this is our plan and it says no more development than the first and 5, then he did misinterpret the policy, and that is a positive misinterpretation. I'm looking what he does say. Thank you, my lord, for reminding me where it comes. On page 161, officer comments. Says these points are directly addressed elsewhere in the report. It's officer's opinion that the extension of the settlement boundary to reflect the first and 5 doesn't meet the test required by 14b. The officer's straight on to 14b there. Yes. He's not using the starting point, which is what do the development plan policies say, and is this application in conflict with it or not? Yeah, and it's point 1 at the top of this page, 161, as has been mentioned by the Parish Council on similar applications for new dwellings outside the settlement boundary. Since 15th November 2017, it's been asked to consider a number of planning applications, etc., etc. Also, it states that development in the Parish Council should be focused within the settlement.
Yeah, there's always the danger, and I'm not suggesting that you've fallen into it, of failing to read the officer's report as a whole. But we do have to bear in mind, don't we, what he said at page 210. At paragraph 3.5.1.
Yes, he says starting point, but what he doesn't do is look at policy 1 and consider whether or not the development complies with or conflicts with it. That's a fatal error. That was the expression used by Lord Justice Lindblom in the Gladman case. Forgive me for 1 second. And I'm grateful to my instructing solicitor for reminding me of the place where I was going to go next, which is the oral advice to committee, which postdates the report. This report was before members, but when they were advised in committee, looking at its tab 9, tab 9, and within that page 261. And it's in 261, towards the top of the page where it says Vincent Pierce Planning Officer, 1 hour 32 minutes 12 seconds.
Yeah.
About 5 lines up from the bottom of that, there's this word tension again. So there's a tension between the neighbourhood plan and the emerging local plan. Then stronger reference even than that, between the hole punches, middle of the page, a line beginning, in relation to both the applications in this parish this morning, there's not actually in strict terms a conflict that engages paragraph 14, it says there, but it's saying no conflict with the development plan. And then tension again comes in at the end of that paragraph. Then another reference over the page on 262, just above the whole punch, line beginning, there is not a conflict that disengages the presumption in favour of sustainable development, ... And the officer could not have said that if he was not misconstruing policy 1. Reference to the same effect, page 270, top of the page, above the whole punch. Neighbourhood plan, this is about 5 or 6 lines in. The neighbourhood plan has only recently been adopted, and yes, it's suggested, and yet it is suggested in response by the strategic planning team that it's already in conflict with the draft local plan.
Where are you?
Sorry, that's page 270.
Yeah. Where?
5 or 6 lines down from the bottom, response by the strategic planning team, that the neighbourhood plan, is already in conflict with the draft local plan. That's policy officers' advice being relayed to members. And again, I keep apologising for these colloquialisms, but effectively standing the neighbourhood plan on its head.
Well, these are observations by Mr Towers, who's an objector.
Well, then, if I've latched on to that, forgive me, discount that, my lord. It's simply going through, picking up the references. I will get back on to members' advice. Sorry, advice to members. Yes, well, then it's. And I am sorry for that. I hadn't appreciated that, my lord, latching into the word conflict there. Have it simply highlighting that as I skated through. 278, Philip Isbell, who is the Chief Planning Officer. In the middle of the page, 230:29. Sentence beginning 5 or 6 lines in. I think at the present time it's not clear to me that there's a conflict because of the words in the neighbourhood plan itself, and I went to those earlier and I won't repeat them unless it goes further. So again, he's saying that policy does not apply. It doesn't set up a prohibition on development outside the settlement boundary. And then he does say that the question of that conflict with an up-to-date development plan, you obviously have evidence behind the draft JLP. So it's setting the JLP against that. And then there's a, I think, final reference. Couple of, actually, it's peppered with them all, but there are two more, which I'll content myself with. One on page 286.
Yes, he says focus, not exclusive, and that it allows for exceptions.
I'm not seeing where that is on 286, my lord. I was
below
looking
the first hole punch. You can see Councillor Richardson.
Yes,
there are 2 lines down. Policy says that growth will be focused, focused not exclusive, focused in the settlement boundaries, and that allows for exceptions to that curve.
Yep.
And then we have the question of whether there's a conflict, and so on and so on.
Yes. So I'm grateful, my lord. Yes, I do rely on that. Focus, not exclusive. That is a misconstruction. I was going to the passage 3 or 4 lines below that. The conclusion I don't personally see, and council doesn't see, a conflict with the neighbourhood plan. Maybe intended, but in this instance, I don't see actually there is a conflict in the way that's described in the NPPF. So that's firmly nailing his colours to the proverbial mast of no conflict. So that is a construction saying there's no conflict with the neighbourhood plan.
Well, that's what I'm not understanding, I'm afraid, Mr. Lewis. He says, in this instance, I don't see actually that there is a conflict. That's my opinion. That sounds like the application of a policy to the facts of this case, not an attempt to construe the policy.
Well, it's an application of the policy which has a right and a wrong meaning, and to the extent that he's saying in applying that policy, I don't see a conflict with having development outside the prohibition in that policy, then in my respectful submission that is necessarily an error, because on the basis of the construction which I've advanced, if development outside the settlement boundary is contrary to that policy, he can't, the officer can't sidestep it by saying I'm applying that policy in a way that admits of these exceptions, admits of these grey areas. That's not right. It's a hard-edged policy. It's one which says within the settlement boundary or without the settlement.
So do you submit that on its correct construction, policy 1 means that it is exclusive and it allows for no exceptions?
Well, it allows for the exceptions expressed in paragraph D, my lord, yes, which are the ones for special needs housing.
Yeah, the express exceptions, yeah, but no other exceptions.
No other exceptions. No.
He did, on your submission, he did misconstrue the policy when he says focused, not exclusive, allows for exceptions.
Yeah, it's as if it's some sort of penumbra. No, focused means directed within, confined within. And I appreciate focus is a word which has potential shades of meaning, but if there's any shade of meaning in it, it's explained by the fact that the focus is for these Thurston 5, the lion's share of the development to be located within, but if there's some which is outside, because it's special needs housing or comes within the exceptions, then the focus for the substance or the greater part of development is within the settlement, but it's only if you're within the exceptions of the policy that you're allowed outside. You're not allowed a 200 dwelling draft allocation outside. And the rationale for that is the expression I've used before, which is that the parish council is saying enough is enough, because they've had the 1,000 or so dwellings in the Thurston 5. And yes, there's one more reference on 290. 290 by the second hole punch. There's not a conflict with the neighbourhood plan.
You may judge that differently.
Yes, but the advice they are being given is that there's not a conflict.
Yeah.
And that's lip service to say, oh, well, who knows what they thought, how they are being directed by their professional officers whom they rely on. They're told that council's advice backs it up.
Well, we know what Councillor Humphreys thought because he tells us on page 282. he says this works against the neighbourhood plan by the second hole punch, but it doesn't actively harm anything as far as I can see. And then Councillor Gould on page 285 says, effectively, he agrees with Councillor Humphreys.
Well, except that Councillor Gould does say later on that he accepts Councillor's advice. Councillor Gould is the one who says, we've heard from planning officers a number of times on this and they've referred to council. So in effect, we're bound to go with that. If I can light on that, I will give, yes, it's page 292. Councillor Peter Gould, virtually the second last page of the meeting. He says, I haven't kept a tally of people's views. It seems to me this hangs in the balance. I'm concerned because the substantive reason, if I may call it, that people focused on in finding a reason to object is as valid as you put it, Chair. The conflict between the two plans, albeit the planning officer says there isn't a conflict, and furthermore Councillor says there isn't a conflict, I'm concerned that if that issue isn't supportable, etc., etc. But that, in my respectful submission, is accepting the balance of opinion that there's not a conflict with the plan. And that's why I submit members were misled as to the proper construction of the development plan. And in a moment or two, I'm going to go on to why that does have consequences, why it matters to the ultimate outcome.
Yeah.
First consequence as to that, I can pick it up conveniently. It's in other places, but because we've got the report open, the vote is recorded. It's the last page of the report, 294.
Yeah, so the majority of one.
A majority of one.
Yeah.
So it only took one to reach the right answer, or as we would say, it only took all of them to reach the right answer.
Yeah.
And it would have gone from approval to refusal. It's also relevant, my lord, out of order, as it were, but I took your lordship to the point about 14b, before the short adjournment. That was the bit in paragraph 310.3 in the report. So the incorrect advice matters as well, because if only the neighbourhood plan had been construed properly, then when it came to this basket of policies point, in the tilted balance in deciding whether policies are out of date or not, again, policy one should inevitably have been included within that. That's the Wavendon point. And again, even though one can't point to a passage where the officer says, I'm putting it in the basket, or taking your point, my lord, that clearly policy one of the neighbourhood plan is referred to in the, I can't say it wasn't considered, but because it was misconstrued, it wasn't put into the Wavendon basket to consider whether one of the most important policies were out of date, because that's what triggers, forgive me, the tilted balance. To make that good, taking up the extract of paragraph, it starts at paragraph 11 of the NPPF, in the short extract. It's letter D, 11D, between the two hole punches, where there are no relevant development policies, or the policies which are most important for determining the application are out of date, you grant planning permission. Unless, and it goes on to give the unlesses, but it's out of date. What does out of date mean? Out of date means literally out of date, but it also says this at footnote 7. One of the classic cases of policies being out of date is, footnote 7 at the bottom of the page, includes applications, for applications involving the provision of housing situations where the local planning authority can't demonstrate a 5-year supply of deliverable housing sites. But we're not in that category, so we're not in an out-of-date policies because they can't deliver sites. But we've got this one policy which is totally out of date, policy 1, in the neighbourhood plan, which is not put into the Wavendon basket of policies. And again, that matters in terms of the balance of considerations in the exercise the councillors did in considering the extent to which the tilted balance favoured a grant of planning permission.
You say that it wasn't put into the basket. It was obviously very much centre stage in the committee's thinking. Is the point that you make is that it, however it was before the committee, it should have been before the committee on the basis that it was frankly being breached by this permission was in breach. It was so it wasn't sufficient to say tension, it had to say there had to be a reference to frank conflict between.
Yes, it comes in two places, my lady. Yes, it comes in at that point. It had to be said there's a conflict because they have to do this starting point exercise, which is this in conflict with the development plan or not? Then under paragraph 11, forgive me, of the NPPF, there's a second exercise they do, which is, well, is the tilted balance applies? Is one of these policies which it's in conflict with actually out of date? So we can downplay it on that basis, but no, you can't do that, or they didn't do that. They didn't say we're now doing the paragraph 11 exercise, the 11D exercise of considering whether policy 1 is out of date or not. And that actually rather goes to the point which my Lord Justice Lewison made at the very start of the case, that this case breaks down to either there was a conflict or not, or you might say the neighbourhood plan was out of date. No, the neighbourhood plan is not out of date. Nobody's saying it's out of date, and they're not saying it's out of date on the basis of inadequacy of housing numbers within it. So that's a second point where it's critical to the council's decision whether the application is in conflict with policy 1 or not. And there's a third place which I'll come to, but yes, my lady.
Can I just check how far we've got? Does the basket come in only on the paragraph 11D point? Or is the basket concept, does it attach to your first point in determining?
It's the 11D point, my lady.
And so it goes to the weight of one of the components, one of the things you put into the basket.
Yes, yes.
It might significantly affect that weight, but it's a weight issue, you'd say, I think. Yeah?
Well, yes, but it's a balance which has to be stayed with, without overextending the metaphor, with the scales at equilibrium to begin with before you do it, without having them tilted one way or the other before you do begin. The third point I was going to make is the one which is based on paragraph 14, which again, this is the one which says when you're looking at a tilted balance case, never mind the unlesses in 11D, when you go to paragraph 14, which is over the page, which is again talking about the tilted balance presumption in situations where the presumption at 11D applies to applications involving the provision of housing, the adverse impact of a land development that conflicts with the neighbourhood plan is likely to significantly and demonstrably outweigh the benefits, provided all of the following apply. And the council said, well, no, they don't all apply. And I accept what the learned deputy judge said, you do have to establish that all of them apply. But what he did do is agree with me that B, in fact, did apply, which was the only one the council said didn't apply. So that applying, the full weight of the presumption displacing advice in paragraph 14 came to bear. And again, it's not dealt with, and the reason it wasn't dealt with is because the council went wrong on policy 1.
Well, you wouldn't get to policy 14, to paragraph 14 of the NPPF, would you? Unless you were thinking of allowing development that conflicts with the neighbourhood plan.
Yeah, yes, my lord, but that's why.
So they must have thought, in order to consider paragraph 14 at all, they must have thought that the proposal was in conflict with the neighbourhood plan. Otherwise, they'd never have got as far.
No, my lord, no, because they said the tilted balance applies because, dear oh me, normally a council wouldn't accept the tilted balance applies. But they said, oh dear, these policies, CS2 and H7, are out of date, in the phrase.
Yeah.
Therefore, the tilted balance applies. Therefore, the developer is entitled to their permission unless there are these additional considerations which we can bring in to outweigh that. It was virtually in their interests, in safeguarding a permission for their allocation, for them to say, as it were, as I put it, oh dear, oh me, we can't rely on the development plan anymore because these policies are out of date. But that means that they conveniently sidestepped the one development plan policy, which at stage one they had to look at under section 38.6, development plan policy, policy one, in the up-to-date neighbourhood plan, comes in at stage two, which is the Wavendon basket stage, if we're considering whether something is out of date or not. We need to look at the policies which are most important. They didn't refer to it, they didn't identify it as a most important policy because they said there was no conflict with it. So again, they had sidestepped it, they had failed to, I've said put it in the Wavendon basket, but they failed to address it head on and consider what the consequences were. Yeah. And that's why, and again, I'm getting ahead of myself here, because there's been mention of the consideration of relief in this case and whether, if one establishes a legal error, that this is just the sort of case which identifies that that kind of exercise is venturing into forbidden territory, because there are so many checks and balances in the tipping of the scales here that one can't say with any confidence what would have happened if actually this committee report had started off by saying this is a conflict with policy one of the neighbourhood plan. Now what do we do about that? It doesn't do that. It put policy one of the neighbourhood plan to one side for, on the basis of a misconstruction.
Yes.
I'm wondering whether I need to go to Wavendon still. Forgive me, my lord, it's in seeking to deal with the points as they come and having covered them, not wishing to get so far, as it were, ahead of myself that there's something I don't then say to deal with. I was going to deal with not Wavendon itself, because the principle isn't in dispute, but to look at Paul Newman, which I put up at the request of Lord Justice Singh, just to show that Wavendon has indeed been approved. No, and I'm so sorry, and I'm hesitating because I had the sense where I jagged off onto relief there, but there was a third point I had to make. Got my stage one point, which is on ground one, which is about wrong misconstruction of the policy. My ground two, which is about not putting policy one into the basket, which it should have been, because in my submission it was obviously material and it said what it said, that you can't have development outside, so it should have been regarded as something which is most important for the determination of the application. And again, three, and this is another one which comes back to balance of considerations, it is the paragraph 14 point, because paragraph 14 wasn't found to apply, whereas the full force of it should have been brought to bear. So that's just to round off the three sort of key points.
Yes.
I make in relation to this. Wavendon. So I've got a couple of points on the facts, but I will go to not Wavendon, but Paul Newman. And I've handed up a copy of that, my lord, but just to identify the terms of the debate. Paragraph 1, we've got Aylesbury Vale District Council. It's paragraph 4 over the page, and they were particularly concerned, it says, last couple of lines of paragraph 4, with policy GP 35 of the Aylesbury Vale local plan. That was a 2004 policy, so it was getting a bit out of date, but it says this, it's referred to at paragraph 6, design a new development proposal should respect and complement, etc., and it's got physical characteristics, etc. It's a sort of details and consistency with local character policy, going right on to whether or not it affects important public views and skylines. Paragraph 13 was the allegation in the challenge, the allegations that the judge erred in construing paragraph 11D contrary to its natural meaning. Or forgive me, no,
Yes.
yes, it's about, oh, well, yes, sorry, that's about construction of 11D of its natural meaning. But yeah, there was a debate about policy G35, which emerges if we riffle right through to page 43.
Paragraph 43?
Paragraph 43, forgive me, my lord, there are no yes, there aren't any page numbers, but paragraph 43. And where we're on to tilted balance again, and it's the Wavendon basket because it is the phrase where the policies which are most important for determining the application are out of date, necessarily involves an evaluation by the decision maker of which the relevant policies in the local plan were. And by this stage, it's G35. I'm back on track here. It's G35 which they're talking about. And and Aylesbury was saying that it was one of the most important. Whether they accord with national policy, as the judge and inspector both found, policy isn't out of date simply because it's in a time expired fan. And Mr. Lockhart Mummery KC, who was for the claimant appellant, didn't seek to contend otherwise. So mere age doesn't make you out of date. Being in a superseded plan doesn't make you out of date, so long as the a time expired plan, forgive me, so long as the considerations accord with the NPF.
Can I just ask you a question about paragraph 43?
Yes, my lord.
The evaluation by the decision maker must it not mean the evaluation at the time the decision is made?
Yes, my lord.
So when Lady Justice Andrews says that the decision maker must decide whether they, that is policies, accord with current national policy, that must mean policy current at the time the decision is made.
Yes, my lord. Yeah. Yes, under planning decision making principles and administrative decision making principles generally. You look at the up to date material consideration.
Yeah. So when you're asking yourself, is a policy out of date? You're asking whether it's out of date because of current circumstances. There they are.
Yes, my lord. Yes, is it out of date now? But simply being a bit old doesn't make it out of date. And even if it's in a plan which has passed its end by date.
Yes, yes.
And so the court does say that here they refer to Wavendon and uphold the reasoning of the judge there. Mr. Justice Dove had to consider the argument that the phrase meant that if one of the policies was the most important was out of date, the tilted balance automatically applied. But he rejected that argument, and that goes on to talk about how you look at the development plan as a whole. But it says this, that he regarded, last sentence on this page, the holistic approach is consistent with the purpose of the policy to put up-to-date plans and planned decision-making at the heart of the development control process. And so I rely on that, my lord, because even though policy 1 is in effect out on its own, it's this single policy, but in accordance and consistence with the purpose of planning policy being to put up-to-date plans and plan-led decision-making at the heart of development control, you need to focus on what the up-to-date policies are, and the ones which are most important, goes on over the page, application of the tilted balance in cases where only one policy of several, of the most important for the decision was out of date and several others are up to date, didn't support the grant of consent would be inconsistent with that purpose. So dealing with dealing with the flip side of here, where one policy is out of date. Then it goes on and says this, that approach is entirely sound, but it's important to note that Ms. Justice Dove was specifically concerned with a case in which there was a group, or it's become known colloquially as a basket of relevant policies to consider. His remarks, taken out of context, can't be used to support an interpretation of 11D, which applies the tilted balance despite the fact that there's a relevant policy in the local plan which is up to date, and that policy is regarded by the decision maker as the most important for determining the application, just because that policy happens to be the only relevant policy. So that's referring back to GP 35, which was the heart of this case. Indeed, Mr. Justice Dove's reasoning about the intention of putting plan-led decision taken at the heart of the development control process points towards the opposite conclusion. So I do rely on that, because what that is saying there, having approved Wavendon, is even in cases where you've got only one development plan policy, which is the most important, you can still have a basket of one, as it were, and that's why I say policy one should definitely have been in that basket, even if it was in the basket for the exclusion of all the others.
Yes.
Now, there were 2 points on the fact I was going to go to, my lord, and this, I think, is probably going to be the only reference anyone makes to the supplementary bundle, but it's a document which was before the learned deputy judge. I'm going in the supplementary bundle to tab 15. This is a decision made by the district council after the Bayton Road application had been to committee, but before the planning permission was granted. Tab 15 in the supplementary bundle, and this is one where the council tried to row back on a decision which had been made without the advice of officers, urging members to find that there was no conflict with the neighbourhood plan. So this is a risk assessment report, and ultimately it says this needs to be brought back to another committee and overruled, because in effect it's inconsistent with the Bayton Road decision, and there's another application by Gladman in the village which is also stalled. Both of those were found not to be in conflict with the neighbourhood plan despite being outside the boundary. But this application was outside the boundary. And councillors, as one can see from the italics in the 3rd paragraph down, it was resolved on this application, which came before the council in July 2020. The application should be refused because it was contrary to the neighbourhood plan, and policy 1 is in there. The other policies aren't relevant. They're about access and landscaping, 6 and 9. So the court doesn't need those, but members regarded that application, which was outside the settlement boundary, as being contrary to neighbourhood plan policy 1. And it says that, as one can see from near to the second hole punch, the council in effect tried to save the situation, obviously being conscious that this was inconsistent with their decision on Bayton Road. But in my respectful submission, it stands as an example of what council members will do when they're not advised to do otherwise in relation to what policy 1 means.
So this goes to section 31, does it?
Yes, my lord, and it goes to section 38.6.
I'm a little troubled, speaking for myself, about references to section 31, because that's not part of the appeal.
Oh, my lord, no, that's what I was going to finish with. Yes, it goes to 31 if anywhere, but that's why I said it goes to 38.6 to my mind, because it shows that the council members construe the policy properly.
Yes, that I understand, and I think that's how the case has been put to us.
Indeed, my lord. And I can promise everybody I'm getting near to the end of what I have to say, but the last point on my speaking note here is there's no appeal against the exercise of the judge's discretion not to quash. I'm getting ahead of myself again.
Did the judge deal with this document?
He did not deal with it, but it was before him, my lord. And another document he did not deal with, but which was before him, which is, in effect, on what I would say is the straightforward construction of the neighbourhood plan. It's what the parish councils say about the neighbourhood plan themselves. That's back in the main core bundle. That is tab 12, page 323. And starting at 322, if the court just sees the date there, 18th September 2019, so just before the neighbourhood plan was made, but in response to and expressing the parish council's representations in consultation on the consultation draft of the first draft joint local plan. And it's really the bit on page 323, which is where the parish council talk about policy 1. Paragraph 4 summarises policy 1, saying development focused within the settlement boundary. 5, it explains what the parish council describes as the general approach of the neighbourhood plan, fully supported by the parish council, has been that growth will be focused on the 5 significant sites granted permission as of 2017, etc., and on small-scale sites within the development boundary. These sites, with the approval for development, are expected to provide high-quality schemes, generally enhance the public realm, improve accessibility for pedestrians and cyclists. Sites shown in the draft local plan are located outside the development plan will neither enhance nor protect the village facilities due to their location within the settlement hierarchy. Shown for Thurston, there are a number of sites that are shown to be outside. LA 87 is the Bloor Homes site, LA 86 and LA 85. They've come forward as part of the allocation of sites, along with a number of sites, other numbers that are currently within the planning system. The parish council challenges the premise that the former 3 sites, that's to say including the Bloor Home site, should be considered as allocations when they're outside of the settlement boundary of Thurston neighbourhood development plan as approved at the referendum. So that's the council saying this is what our plan means. I can appreciate that one can say that if, as a matter of fact, it doesn't mean what they thought it said it meant, that might be a problem. But this is, again, significant contextual detail in my respectful submission, which corroborates the passages in paragraphs 4.1 to 4.6 of the text of the neighbourhood plan, which is, I've summarised by saying that they're saying enough is enough after the first and 5. So that's by way, as it were, of a reality check on what the intended consequences of the of policy 1 in the neighbourhood plan were. And if the court will forgive me for a moment while I take instructions, I'm nearing the end. I've only got 5 or 6 more points to make, subject to this. Thank you, my lord. The first of the closing points I was going to deal with was simply to say about Chichester again, which I mentioned, that one doesn't read across from one plan. Then if I've dealt with that, I won't waste time by going back to that. But again, the circumstances there in my respectful submission were very different from here, because you had plans and tenants. Okay, I won't waste time with that, my lord. Then again, any suggestion that, yes, as I've put at the forefront of my submissions, the misconstruction of Policy 1 is a point of law here. It's not an issue which admits of planning balance. It's not a point which is tripped up by saying, oh, well, the council acknowledged that there was a breach of the development plan anyway, so it doesn't matter. They needed to get, as I put it, the right development plan. They needed to do the Wavendon basket exercise.
Yeah, I think you've made this point too, Mr. Lewis.
Very well, my lord. But coming to deal with the 3 points which my Lord Justice Lewison made in the early course of argument this morning, there's the one consideration whether there's a conflict with Policy 1 or not, and if there's not, end of, and I accept that, but for the reasons which I unhesitatingly submit, there is a conflict. 2, whether the neighbourhood plan is out of date. No, it's not, in my respectful submission, my lord, and importantly, nobody has suggested that. Just being out of step with the draft housing figures which are currently put forward and are still subject to a process of scrutiny which has not even concluded. Yeah. 3, again, well, I've dealt with the point just a second ago. It's not a section. It's not. Oh, well, we've got section 38.6, there's an acknowledged breach of the plan, so we're looking at material considerations. But even if we are looking at material considerations, then this really is coming to my last point, which is on section 31, and whether it isn't all, as my learned friend Mr Cosgrove put it for the council, a classic exercise of planning judgment, weighing up all the competing considerations. No, it's not. And these highways improvements, which have been referred to, pick up Lord Justice Singh's point in relation to those, that those were actually matters which for some reason weren't exacted as requirements of the Thurston 5, and so to treat them as an added bonus of this application now is 1, self-serving, and 2, in any event, because this isn't a balance of considerations matter, it's not a section 31 case, it's not one where anyone has challenged the learned deputy judge's very careful assessment, having identified what he, with all his learning and experience in the planning field, identified as well, 3 errors of law. No ground of appeal, and in any event, no grounds for suggesting that, having regard to those legal errors, the council's decision should somehow be saved by this court exercising in effect a planning judgment to decide that there's no purpose to be served by quashing.
Yes.
My lord, those are my submissions.
Thank you. Mr Tucker.
My lord, I think I have 7 points to make in response, and I'll do so hopefully quickly. Before I do, can I just say, you've not heard submissions from me in relation to ground 3 and ground 2. I've adopted my learning from Mr Cosgrove, and I say nothing about those, with one exception, which is the obvious point that my Lord Justice Lewison indicated to my learned friend, which is paragraph 14, the ground 2 points go nowhere if we're right that there isn't a conflict with the local plan, with the neighbourhood plan.
Ground 3 is not, in fact, in your grounds of appeal.
Not at all, my lord. So another good reason why I'll make no submissions in relation to it. So, my lords, first point is the criterion A of the neighbourhood plan, and focused, and my learned friend suggesting that's somehow synonymous with located within, and points to the exceptions. Can I take the court to the policy, which is page 105? And my learned friend suggested that criterion D is confirmatory of his conclusion that this is an overall approach which has a preclusive element to which D is an exception. Make the obvious point, which is C. So A and B we've already looked at in depth, which is those are said to be encouraging of development within the settlement boundary, but said by my learned friends to be preclusive of development outside it. And then we've got C. All new housing proposals will be expected to address three sub-criteria. And then E, where development uses best and most versatile agricultural land, it must be clearly demonstrated. So we've got 2 criteria which identify how you treat applications more generally. Why do I say that's consistent with the interpretation that I urge upon the court? It's a simple one. If I put myself in the counterfactual position of the local plan having been adopted with a housing allocation, whether it be this site or not, but a housing allocation which is materially smaller than the Thurston 5, would there be an inconsistency with policy 1? Well, no, because there would still be focus within the settlement boundaries, and there would still be parts of policy 1 against which you would have to judge such a development, i.e. C and E. I say it is a policy which is emphatically not preclusive. And points don't get better by repetition, but my point with regard to the countryside policies of the local plan, which have resonance with the Chichester case, would be the answer to the issue of non-conformity with the local plan, because such a site will be allocated in those circumstances. And I'm sure that I said the point before the short adjournment. If I didn't, I make the obvious point. Chichester came after Crane and Gladman, and Lord Justice Lindblom deals with the issue as to the supposed inconsistency with the Chichester decision and the Crane and Gladman decisions. And whilst it's right to say one doesn't read across, nonetheless, that doesn't mean that that's devoid of all meaning to look at the nature of the policies. And I draw particular attention to Lord Justice Lindblom's paragraph 48 of his judgment. Third point, in relation to what the neighbourhood plan was doing, the neighbourhood plan was emphatically not seeking to allocate land to 2036. For all the reasons that have already been submitted, the neighbourhood plan was identifying what the commitments were, and within its reason justification was explaining that it was hoping that it wouldn't have to make significant additional allocations, but was expressly deferring that decision to the local plan. It is a mischaracterisation of the neighbourhood plan to suggest that it was meeting its needs within the terms of paragraph 14b. Out of datedness, if there be such a word. It's said by my learned friend Mr Lewis that it's said by nobody that the neighbourhood plan is out of date. Well, what is said in terms by the officer's report over and over again is that it doesn't meet up-to-date needs. Now, whilst it's right to say it's not grappling with the word, does that make it out of date or up to date, it's making it very clear to members it isn't doing the job of meeting up-to-date needs. Here are the up-to-date needs. If that's not out of date, frankly, it's difficult to see what it is, but it's certainly not meeting up-to-date needs. And on any view, it's suggesting that it's not fulfilling the complete purpose as one would expect in relation to a policy, but particularly if it's a policy which is intended to be preclusive in the way that's been suggested. Misconstruction. Can I just take the court to page 211 of the core bundle? The way in which the officer's report is set out is almost the antithesis of subheadings, because one has subheadings not in bold and subheadings which are not identified. But if one looks at paragraph 3.5.7, that's the start of the discussion in relation to policy 1. Immediately below it is criterion A of policy 1, and then there's an officer comment in relation to criterion A, and then criterion B, and then an officer comment in relation to criterion B. Far from not engaging with policy 1, the officer's report engages with it at depth. And what the officer says under officer comment under A is essentially the proposition that we've put forward, namely that the neighbourhood plan does not allocate new developments, new sites for development, but reflects the likely status quo arising from planning permissions, not meeting needs, recognising consents. And then I think if there is an alleged misconstruction in the counterfactual world that Mr Lewis is writing in his interpretation of the officer's report, it's B going on to the top of page 212, because that's where the officer says B is not relevant as the site lies outside of the defined settlement boundary shown in the neighbourhood plan. Now that's precisely what's said in the officer's oral submissions as well, i.e. because it's outside of the settlement boundary, that's not in breach of a policy which doesn't preclude such development, but it does mean there's a tension there. That assessment is entirely consistent with that. And then finally, I think, in terms of points that I'd just like to pick up, section 38.5. If I can invite the court's attention to the document that was handed in after the short adjournment.
Yes.
In the same way, I think I can do, I'm able to deal with ground 2 very quickly. 38.5. If to an extent a policy contained in the development plan for an area conflicts with another policy in the development plan, the conflicts must be resolved in favour of the policy which is contained in the last document. What is the conflict in this case? Well, there is a conflict as between the policies of the local plan and the neighbourhood plan, is that the settlement boundary of the neighbourhood plan conflicts with the local plan because it's been expanded to take account of the Thurston 5. Therefore, that trumps what's in the local plan in terms of the settlement boundary. My learned friend's point appears to be that one can look to policy 1 as trumping policy H7 and CS2, brackets, which happen to be out of date, close brackets, by looking at the policy 1 implicit in preclusion on development in the countryside. Well, with respect, that's nonsense. Policy 1 doesn't trump policy CS2 and H7, and the question as to whether they are or aren't out of date is an entirely separate judgment. All it does is it trumps the geographic extent of the countryside to which policies CS2 and H7 apply.
Can we just be clear why they are said to be out of date? Is that because of the amount of housing that would be needed?
I think there are 2 reasons, my lord. It's obscure from the purpose of the officer's report. There have been past decisions where there hasn't been a 5-year land supply and they've therefore been presumed to be out of date. But I think the recognition is the geographical extent of policy CS2 and H7 where settlement boundaries have been drawn is out of date because that doesn't then match the extent to which there is an up-to-date housing need.
But is your fundamental submission that they're not out of date in the material sense, namely that they do still preclude general housing development outside a settlement boundary?
Absolutely, my lord. And to take up the Chichester case, looking at paragraph 48, settlement boundaries being established in the neighbourhood plan, the approach to decision making on development outside of the settlement boundary is not merely implicit, it is set by the express policies of the development plan. Now that's said by Lord Justice Lindblom in relation to that case, but it's said it's applicable in this case directly with respect. And that's why it is distinguishable from the Crane case and the Canterbury case, where there were no settlement boundaries and that automatic preclusion wouldn't apply, where the court then had to interpret that that was then a comprehensive approach to development in relation to those particular neighbourhood plans. It's on all fours. My lords, my lady, unless I can assist you further, those are my submissions.
Thank you very much.
Thank you.
Yes, Mr Cosgrave.
Lord Grateful, I have 4 very short points, if I may, my lord. I'm just going to add one, actually, in light of that last debate about out of date. In practice, whether something is out of date in MPPF terms is normally addressed by reference to another part of the MPPF as being an exercise on whether the policies can be said to be consistent with policies in the MPPF. And that, as you can imagine, involves an enormous amount of judgment. And as my learned friend says, I suspect in this case, they were found to be out of date for a number of reasons. do with supply, but also, for example, because up-to-date countryside policies, for example, in the NPPF have more of a balance as to whether development should be allowed, whereas policies of that vintage tend to be more just outright reclusive development. But that's a slight digression. Well, my first response really relates to the issue of construction or application question mark, and I see no reason to change my submissions at the outset to the effect that this really is an application case. There is in my submission no support for the contention that policy 1 in the neighbourhood plan, when one looks at the wording, precludes. Whether you're construing that or looking at the wording as a matter of common sense and applying it, there's no support in my submission that it precludes development in a way that means the boundary should be considered a barrier to new development, which is part of the way the learned judge Belay put it. And look, I also make the subsidiary submission in relation to that, that if one is of the view when one looks and applies a policy, as perhaps was this case, that there may not be explicit support, might even be a tension with it, that is not the same as saying you are precluded by a policy from developing in a particular area, or that there's a conflict with it. My second point relates to baskets, and Lord, I would simply say this, that this is a case when one looks at the report, the committee report as a whole, particular planning balance and conclusion in section 4, which makes it abundantly clear that the neighbourhood development plan was at all times in the forefront of the considerations of the officers as put to the committee and their assessments. In my submission, there is no basis to suggest that the Neighbourhood Development Plan Policy 1, nor indeed the other Neighbourhood Development Plan Policies, 9 were grappled with, and some in some detail, were ignored or sidelined in that exercise of planning judgment in relation to the Wavendon basket. But my third point relates to looking at paragraph 14, and I would just make these submissions, that in this case, the principal point is, the Council's case, that paragraph 14 never, in a sense, bites because there was no conflict. But even if that was not the case, for the reasons I submitted earlier, this neighbourhood plan chose not to identify its housing requirement. Say, could have done, but it chose not to. And for that reason alone, 14b, if one got to that stage, would not bite. Even had it identified its housing requirement, it didn't contain policies or allocations to meet any such requirement. And for that reason, again, 14b would not bite. And even if I think those are the points I think I'm making. 14b.
I think what Mr. Lewis submits is that the word "its" is very important in paragraph B, or subparagraph B of paragraph 14. He says that what you're really saying is that it ought to identify some further housing requirement, but that's not to the point, because what the policy refers to is its identified housing requirement.
Well, as I say, it didn't identify any, so it was non-point. I think although I don't think it's directly relevant here, you would have to apply that in the current circumstances anyway, but that in a sense is going a stage further. I think the learned judge is wrong on that front as well. And Mr. Lewis did say that I think there was some suggestion that my client as the district council should perhaps or could have challenged or rejected the neighbourhood plan. It couldn't have, in fact. There would have been no lawful basis for my client to have rejected that neighbourhood plan on the basis that it hadn't identified its housing requirement or contained policies or allocations. There's no legal requirement for it to do that. The benefit, the carrot for a neighbourhood plan to do that is that if it did so, it may then gain the benefit of paragraph 14 in the decision-making process. This is a neighbourhood plan.
And presumably it can make representations to the examiner.
Yes, I mean, absolutely. It can choose to do it at the outset and scoping what the neighbourhood plan is going to contain. Normally there will be a decision whether we are a neighbourhood plan that's going to choose to identify the need. It may be, depending on the timing, that someone's already identified a need for the neighbourhood plan, and in which case let's allocate. But if you don't do that, either of those things, you're not going to get the benefit of paragraph 14. There is no requirement for you to do so. A local authority in my client's position couldn't refuse or reject a neighbourhood plan presented to us because it hadn't done so. That's the neighbourhood plan is called. So, with great respect, I don't think it's quite right to suggest, if it was being suggested, that my client could or should have rejected it on that basis. Well, those are my only submissions.
Thank you. Well, thank you all very much for your submissions. It will not surprise you to learn that we will reserve our judgment. You will get a draft judgment in the usual way. It will be circulated to those whose email addresses you have given to our clerks. It will be the solicitor's responsibility to distribute the draft, but strictly in accordance with the embargo, which you will see on the front sheet of the draft, and which means exactly what it says. Any breach of the embargo may be treated as a contempt of court. In the light of the draft, we would expect you, first of all, to correct any typographical errors that are made in the line of factual errors, not the occasion for re-arguing points or opening up new ones, and we would hope that in the light of the drafts you will be able to agree a form of order. If you can't agree the form of order, please make short submission in writing, and we will make the form of order that we consider to be appropriate. Thank you all very much.